We are here this evening to hear an appeal by the Buena Vista Residents Association of the hearing officer's determination in the Buena Vista Mobile Home Park closure matter. Council's role in this hearing is to determine whether the hearing officer's decision, as it might be amended by the council, provides for a package of mitigation measures that are adequate to mitigate the adverse impact on the displaced residents, provided that the package does not exceed the reasonable cost of relocation. Once we have identified mitigations that meet this criteria, we must approve the closure application. We are not here to discuss whether closing the park is fair or the right thing for this community. The park is privately owned, and the owner has a right under state and local law to go out of business, provided that he mitigate impacts on displaced residents to the extent required by law. We are also not here tonight to discuss the hope and aspirations of many of the communities that Buena Vista can be preserved for affordable housing. That is not within our jurisdiction tonight. We are aware that other community and neighborhood leaders are working toward that goal, and our city manager has informed us that he has set aside city funds, so at the right time, we can have that discussion here. Before we can turn our attention to those issues, we must first consider the closure application. We have an obligation to be neutral, unbiased, and fair, and to reach a decision based on the evidence before us. Only after this process is concluded can we participate in a broader community conversation regarding Buena Vista.
Thank you, Vice Mayor. So just a few reminders from where we left off last night and a couple of carried forward items. So as you recall, last night we took all the public testimony. We will hear no public testimony this evening. We concluded that last night. Also, we ask that anybody here please refrain from any kind of outward expression of support or lack thereof. And actually, before we go on, if the interpreter could come to the mic and make sure that that's interpreted so that everyone understands that, if you would, please. So what we will be starting with this evening, go ahead, thank you.
Por favor, restringan los aplausos y las expresiones de apoyo o de contradicción que está considerando aquí hoy. Gracias.
And this is so, sir, and this is so that everyone will have an even playing field and will not feel discouraged or encouraged.
Es para que todos tengan un campo equitativo e igual para todos y que nadie se sienta o animado o desanimado.
And we appreciate your consistency with that.
Agradecemos mucho que sean consistentes con eso.
Thank you very much. So where we left off last night is with the expert witness from the park owners. So you will have 10 minutes. Then we will go to hearing rebuttals from each attorney. So we will go back then to the resident's attorney for rebuttal comments. You'll have 15 minutes. Then we'll go to the park owner's attorney for 15 minutes of rebuttal. Then we'll return to council for questions of attorneys, consultants, or city staff. So is your expert witness here, please?
Yes, ma'am. I'd like to introduce Mr. David Beckman.
Thank you and welcome.
Thank you. Thank you for the opportunity to speak briefly to you this evening. I'm going to address 4 issues, or just to clarify some of the issues that were brought to my attention earlier. First of all, I'll call it A, location issues. The Palo Alto location versus buyers' acceptance of park deficiencies. First of all, these homes largely are unable to be financed due to age and the fact that all the additions that were made to them have no permits. The dated homes in the subject park and the competing parks typically are not financeable. If you look at the park history, shows only one reported finance sale over more than a 20-year period. The typical transaction is an all-cash sale. The park has also very small pad sizes for the most part, except in one back section of the park. The infrastructure in the park is inferior and dated. This leaves the park in a situation where you're unable to replace the old homes with new manufactured homes. There are a few park model units in the park, however, they are not manufactured homes and are not able to be financed. Space rent also partially offsets location, and there's a lack of park facilities. The buyer's acceptance of these deficiencies is the location adjustment. It's embedded in the data. Homes in this price range are providing the most basic and lowest cost housing, which is true of all comparable park locations. Buyers in this price range are concerned primarily with basic shelter. This conclusion was drawn from the following information. First of all, we studied sales history in the park going back 20 years, as published by not published by HCD, but HCD data published through Santiago Financial in the comp report. It showed no correlation at all with the Palo Alto residential market at any time in the past. Number two, comparing in-park sales with sales in competing parks in nearby community did not show a premium for the Palo Alto location beyond the buyer acceptance of the park deficiencies and space rent differences. Number three, we did a median sale price comparison for mobile home parks in Santa Clara County. Condominiums and townhouses in Palo Alto and single-family residents in Palo Alto were also analyzed by the appraisers. Clearly, no correlation was noted between the conventional housing and the mobile home park data in the park or outside the park. Number B, or letter B, in our standards of practice under Use Map 2012-13, which governs this appraisal assignment, 7-4, we have to collect, we have to verify, and then and only then can we analyze data. Market data is collected and then verified, and it can only be utilized after it has been confirmed. Now, we have an unusual situation in here in that the MLS isn't handling the sales for the most part. I think we only found maybe 2 sales that were on MLS. So we turn then to the HCD data as published by the comp report by Santiago Financial. And we looked at that data, and then we looked at that data and remembered that that data has a lot of holes in it often. And that oftentimes the data isn't reported through that data service, or it's tardy in getting there. So we called Santiago Financial, we spoke with Byron Levering, who is their IT person that manages the data bank, and had him research going back 20 years to get a list of all the homes that had sold in the park that were verified through HCD. And we have that in our file. And it's in every report. We also cast a wide net because we figured that a lot of the data is not going to be in that data bank. And we put a park questionnaire out in both English and Spanish, trying to gather in as much information as we could. 2 of the questions in that questionnaire were, when did you buy your home and what did you pay for it? And also, what improvements have you made to the home and are they permanent? We didn't get a lot of those back. Mostly we did not get them back. And we repeatedly asked for them. We conducted as many as 40 trips to the park. We posted those notices on the doors multiple times asking for that information. The data bank for manufactured housing is weak. The 2 primary data sources, as I mentioned, are MLS and the comp report. MLS is largely not utilized by market participants for the park. The comp report is often tardy in reporting the information they retrieve from the state HCD and an overall weakness in the data bank. And I cannot fix that other than the steps that we took. C, the principle of change. The Appraisal reports are based upon an effective date. They are based primarily upon all available market data as of the effective date. It is simply a reflection of buyer-seller interaction in the marketplace. As time passes, the pertinent data changes as new sales enter the data bank. Since the time of the assignment in early 2013, prices have increased. Again, prices have increased. If the appraisal reports are completed today, the valuations are likely to be significantly higher. The market's gone up. And then there's that last issue on the hypothetical condition. We chose a hypothetical condition to forgive the unpermitted additions. If I would have chosen an extraordinary assumption, to release the extraordinary assumption, I would have to get verification that the additions were permitted. I would have to have some proof of permitting. So I would have valuations floating nebulously in the air that I couldn't even release to the client. The hypothetical condition tells the truth. The permits are not, the additions are not permitted. So that's the truth being conveyed. And if you know something to be true, you have to make it a hypothetical condition. The definition is a condition directly related to a specific assignment which is contrary to what is known by the appraiser to exist on the effective date of the assignment result, but is used for the purpose of analysis. It would have been misleading for us to use an extraordinary assumption because we knew that it was true that they were not permanent. I tell the truth in my appraisal report. Anything that even hints at not being the truth, I avoid. So we chose a hypothetical condition for those reasons. I believe it's the correct way to go. I would do the reports again in the same manner and same fashion as I did previously. The only difference today is time. The data bank now is more complete, and also there's a whole new set of data for the comparable sales we would select outside the bank. In regards to the valuation, the issue of the hypothetical condition and the unpermitted additions is mute to the park residents because they were included in the valuation with forgiveness of the issue. I want to just finish, the issue of permitting seems to be largely ignored by market participants because these homes typically are not financeable, require cash from buyer to seller, and most importantly, buyers in this price range are concerned mainly with basic shelter in an area sorely lacking affordable housing alternatives. Thank you. Is there any questions?
Thank you, and we do have a minute and a half left, should you want to use it.
I end my time.
Okay.
I don't have anything more to say.
Thank you, thank you very much. And I will be doing this periodically. I'm looking to our city staff to see if you have any comments now that we've reached kind of a threshold. We've heard from both attorneys and both expert witnesses. Do you have any comments that you want to make?
I do not at this time. It might be appropriate to move to the attorneys for rebuttal, but it is my understanding that council may wish to question the attorneys and their experts, and so I hope that folks are planning to remain available for that as the evening wears on.
Yes, I'm sure there will be questions. So now we move to the park residents attorney team for rebuttal, and you will have 15 minutes. I'm sorry, you need to come to the microphone so we can hear.
Is it okay if we get just 2 minutes to discuss the comments that were just made by the expert?
Sure, yes.
Thank you. So thank you again for your time this evening. Again, my name is Nadia Aziz. I'm with the Law Foundation of Silicon Valley, and we represent the Buena Vista Mobile Home Park Residents Association. So I'd like to make a few comments in response to the park owner's presentation last night. And I'd like to also discuss what our ask is of the City Council. So the park owner last night made arguments regarding related to the Constitution. So both state and Palo Alto ordinance require that the park owner mitigate the negative impacts of the park closure before the park can be closed. And state law requires this because of the unique nature of mobile home parks. they're a unique form of homeownership where you own a mobile home but rent space. And California recognizes that it's one of the last bastions of housing and homeownership opportunities for low-income individuals. So because of this, if a park owner wants to close the park, they must mitigate the negative impact. And Palo Alto's ordinance specifically protects the property interests of the park owner by allowing the park owner to ask for either a partial or complete exemption to require relocation assistance by showing that providing relocation would substantially limit the park's reasonable use or economic value. So that really is to protect the park owner's property rights and to protect their constitutional rights as well. The park owner also talked about the reasonable cost of relocation and how the mitigation assistance should not exceed the reasonable cost of relocation. The ordinance specifically describes what the park owner needs to do to mitigate the negative impact of the park closure. The ordinance specifically lists the requirements, including providing comparable replacement housing. And so the term reasonable cost of relocation is not defined in the ordinance, but is in the ordinance in relation to what the ordinance anticipates the park owner providing. So it anticipates that comparable replacement housing is going to be reasonable. Because reasonable cost of relocation is not defined in the ordinance, we can look to state law. And state law looks at replacement housing as reasonable. So when we're talking about reasonable cost of relocation, replacement housing is contemplated by both the ordinance and by state law to be a reasonable mitigation cost. The park owner's arguments last night also ignored that the ordinance really looks at what it takes to move to comparable housing and not the appraised value. And the park owner really continues to advocate their responsibility to come up with a plan to allow residents to move to comparable housing. For example, the park owner's presentation mentioned HCD sales. However, that data was not provided as part of the relocation impact plan. And if such housing does exist, if the HCD sales reflect that there are comparable places that residents can move, they need to be identified as part of the plan. That's what the ordinance requires, a plan to allow residents to move to comparable housing. We still don't know what comparable housing is. The park owner during the presentation last night tried to show you what's not comparable, but they haven't really described what comparable means. And that's why the ordinance requires a plan. That's why analysis needs to be done as to what constitutes a comparable community. Where are the sales? Where are those mobile home parks? How are sales made? Where can families go to try to find these comparable mobile homes? And again, it's hard to determine whether or not this assistance is going to allow residents to move to comparable housing, and we don't even know what assistance is. We have no numbers right now, and we don't know. And that's very problematic considering that this is the final decision that the residents will have. The park owner also showed you some mobile homes, and this was to, and these mobile homes really are not reflective of the vast majority of housing available at Buena Vista or housing that exists at Buena Vista. These really shouldn't be what the park owner showed you really should not determine what the values of the homes are. You know, there's a reason that the ordinance asks for appraisal to be done. And you have not only the park owner's appraisal, but our critique of the park owner's appraisals and methodology. And that should really be what you should use in trying to determine what the values of the mobile homes in the park are. The park owner also talked about the rent subsidy that is available to residents. This is the 1-year rent differential. And again, they discussed why most of the mobile homes are small and should only be, and that's why a one-bedroom should be used for as a comparable unit. However, this ignores the fact that the ordinance actually contemplates looking at the ordinance specifically requires the rent differential to look at what the new location's rent is. And so we're looking at actual costs, and that's what needs to be reflected. Most families, because they're large, are going to be moving to larger units than a one-bedroom. Lastly, the park owner described the relocation specialist and described that the hearing officer's decision allows the relocation specialist to change the mitigation and to increase the relocation assistance. If you look at Exhibit A to the hearing officer's decision, which was referred to, that's actually not true. The relocation specialist can change what the moving costs are, but they can't change all of the relocation assistance. They just have some flexibility in determining what the moving costs are and what the assistance for disabled families are. So the City Council should find tonight that the mitigation assistance is inadequate, because it will not allow residents to move to comparable housing and will not allow residents to purchase a mobile home in a comparable community. So what is our ask of the City Council tonight? The City Council can instruct the park owner to come up with a specific plan. The City Council can require the park owner to have a plan that specifically defines terms, specifically defines comparable housing, and requires the park owner to come up with some analysis. Specifically, the City Council can require the mobile home to require the park owner to look at where those comparable mobile home parks are, can instruct the park owner to look at what comparable communities exist, and can assist them in defining what a comparable community is. Does a comparable community mean a community with similar access to high-quality schools, similar access to public transportation, similar access to hospitals and recreational facilities? We know that the similar community will not mean Palo Alto. There are no mobile home parks left in Palo Alto. And we're not asking City Council to require that the park owner buy all the residents a $1.2 billion condo. But what we suggest that the City Council do is instruct the park owner to come up with a plan that specifically requires them to look at what it would take to move to a mobile home in a comparable community, a comparable mobile home park within 35 miles. We also request that the City Council require that appraised value be a floor, not a ceiling. And I'll discuss in a little bit what our ask is when it comes to appraised values. Lastly, the City Council should require that if there are residents who choose to move into rental housing, that they be compensated not based on a one-bedroom, but based on the actual cost, based on their actual rights, and not the one-bedroom. So we've articulated our concerns with the appraisal methodology that was used. And there are several ways that City Council can address this. One, they can require that appraiser to actually consider in-place value. The appraiser has stated that in-place value, that he didn't consider in-place value because of the condition of the park. The City Council could require the appraiser to consider in-place value. They can also allow residents to get a second appraisal. Many jurisdictions allow residents to get their own appraisals. They offer residents to do multiple appraisals, so that's another option that the City Council can do. They can also allow a hearing officer or another third party to choose between the higher amounts, or to choose which amount they feel would most adequately mitigate the negative impacts of the park closure. Lastly, we request that the city council not approve mitigation measures without a third-party review. At this point, we do not know what the relocation assistance is. Residents should be able to appeal the relocation assistance to ensure that it complies with the ordinance. And the ordinance contemplates a third-party review. And this includes review by a hearing officer and by the city council. So after the park owner does come up with a plan, the city council should require that this plan be subject to review if a resident feels that the mitigation assistance is inadequate. We understand that this is a difficult decision that is in front of you. And we thank you again and thank the staff for their work and their consideration. We're happy to answer questions to allow you to make this decision easier. And again, we request that you find that mitigation assistance is not adequate.
Thank you. You have 3 minutes left, should you care to use them.
Yes. So I just wanted to add, when the city council rejects the mitigation assistance, the city council can require specific instructions of the park owner. The city council should instruct the park owner to consider schools when looking at comparable housing, and should specifically require that the appraised values be floored on a ceiling. So what our ask is that the city council reject mitigation assistance, and if the city council the city council can instruct the park owner to come up with a specific plan, because I think that's the key that's the key that's missing here. There's not a plan to relocate residents to comparable housing, and so the city council can and should come up with concrete definitions and concrete things that should be in that specific plan, including considering schools and looking at comparable housing. It should instruct that that comparable housing have similar amenities to Palo Alto, and that it be enough and be adequate enough to allow residents to purchase a mobile home in a comparable community within 35 miles. That's really what the ordinance requires. And with the relocation assistance that's being provided, it will not allow residents to move to comparable housing in a comparable community.
Okay, thank you very much. I'm sure there'll be questions. So now we move to the park owner's attorneys for rebuttal. Again, you will have 15 minutes.
Your Honor, I just need the mouse for the
Okay, Council and Mayor, I am again Margaret Nanda, appearing on behalf of the park owner. I want to begin the rebuttal tonight with Mr. Lavity's decision, which again, I remind the Council was the hearing officer appointed by the city attorney. Mr. Labadie, a former city attorney for the city of Walnut Creek, who still represents the city of Auburn, the hearing officer, you will note in his decision, did not find that the park owner must purchase comparable housing for the homeowners at Buena Vista. And why is that? Does that suggest that Mr. Labadie either did not read or did not understand the ordinance, at least as the Residents Association sees it? And I would submit not. I think that if you review Mr. Labadie's decision, you will see, even if you do not agree with any or all parts of it, that it reflects careful and reasoned analysis, and that he spends nearly 30 pages explaining each particular matter that was put before him. And he, in fact, the reason he does not require the park owner to purchase comparable housing is because to do so would exceed the reasonable cost of mitigation per government code section 65863.7. Then, again, I want to discuss in the context of the actual trailers and mobile homes at Buena Vista, a point which the Residents Association just made and which they made last night. The Residents Association has suggested that Mr. Labadie was incorrect in his finding that unless the trailer, RV, or mobile home was manufactured with 2 bedrooms, that the mitigation assistance for rent subsidy, which I might add is for market rate rents in Palo Alto and surrounding cities. It is not affordable housing rents or subsidized housing rents or even mobile home park rents, such as Mr. Gisser's, which are controlled by a rent control ordinance, which this ordinance also contains. He said, because he recognized that the additions, and Mr. Beccaria also addresses, the additions such as the ones you see in these photos, which include, for the one on the left, a roof, an additional room, and again, a picture on the right, and then again is well illustrated with respect to this RV in which they have built a stick-built room next to it, and you see the other side of the same RV. Now, Mr. Gisser did not object or did not enforce, it is correct, he did not prevent these people from building what you're looking at Space 49. And now then, they're suggesting, so let's assume we don't know what that room is used for at Space 49, for example. An RV of the type that is featured there would normally be a 1-bedroom RV. Assuming that they use it as a bedroom or living room or otherwise, first of all, Mr. Beccaria was instructed and in fact assumed all additions were in fact legal. Secondly, however, Mr. Labadie correctly found that if in fact Mr. Gisser had allowed the park owners, the mobile home owners, the ability to expand their houses, which they have done in the fashion which we are showing you, for example, in this picture, that does not mean that the park owner, under the terms of the ordinance or state law, is required to give them a bigger, not give them, but to either purchase a comparable mobile home. This is, again, not a mobile home, but one that is bigger than what they are living in, because comparability also includes size. And Mr. Labadie returned to the premise that whatever the RV, trailer, fifth wheel, whatever type of trailer or mobile home which is located at the park, when it was manufactured, it contained a certain number of bedrooms. If that bedroom was 1, then the park owner is required to provide the residents as an element of mitigation assistance, market rate rent subsidy for a total of 15 months when you include the startup costs. Then I want to address the issue of something that the Residents Association, in my view, raised for the first time last night, but have again repeated it tonight. And that is the words, housing relocation plan. Last night and again tonight. We, the park owner, are found wanting because we have not provided a housing relocation plan. I will represent to the council, and you can do your own word search of the ordinance. The words relocation, housing relocation plan do not appear anywhere in the ordinance. We are not required to prepare or provide a housing relocation plan. And considering that the Residents Association attorneys provided a written letter every time we redid or provided the city with a new version of the resident impact report, if they believed at any point in this process that we were required to provide a housing relocation plan, I would have thought we might have heard it before last night. Certainly, those words were not used to my recollection, although I could review the transcript, at even the 3 public hearings which provided this. The ordinance provides that the housing relocation specialist assist the residents in finding and moving to relocation spaces and comparable housing. That is the job of the housing relocation specialist. We pay for the housing relocation specialist. We do not instruct the housing relocation specialist, but it is the job of the housing relocation specialist to, in fact, do that. The housing relocation specialist, in fact, creates a plan after working individually with each resident. And it is up to the park owner to defer to the specialist and to not interfere in that process. In the present instance, again tonight, we are told that we have failed to identify specific comparable parks, specific mobile homes for sale, specifics. And again, as someone who has closed 6 parks and has been doing this law for a long time and is closing currently four currently, if you look at your ordinance, the ordinance requires us to provide data regarding mobile home parks in the first version of the housing relocation impact report. It is a snapshot in time, council. So today, if I sit here and tell you that at Adobe Wells Mobile Home Park in Sunnyvale, there are 4 mobile homes for sale that range in value from $55,000 to $255,000. That is a snapshot in time as of today. We don't know when this park will actually close. You know that, or I believe know, that under state law, even after the conversion impact report, or the resident impact report, under the ordinance is approved, and the mitigation assistance is approved, the park residents are entitled to at least 6 months notice of the closure. It is during those 6 months that they will work with the housing relocation specialist, and they will, with the lump sum assistance that they will be given, they will choose housing. And which brings me to my next point about the payment of the lump sum assistance. Your ordinance provides for payment of lump sum assistance. And in my view and in my experience, the payment of lump sum assistance clearly contemplates that the homeowner and the housing relocation specialist will together explore and choose the best option of relocation for that homeowner. So for example, the rent subsidy, the market rate rent subsidy for 15 months that we will pay, that the park owner will pay, is not going to be paid piecemeal month by month to whatever new housing the resident selects. It's all given to the resident in a lump sum so that they, in conjunction with the housing relocation specialist, will choose what is best for that person. While the Residents Association tonight recognizes that Craig Labadie did vest some authority in the housing relocation specialist, yes, it is of 2 matters. It is with respect to the amount of the relocation assistance and the amount of assistance for handicapped and disabled residents, which could be significant. Did he vest further responsibilities in him? No, but that does not mean that, but if you read the end of his decision, he explains why he cannot retain jurisdiction. I also think that the council must reject the argument that the appraised value of the homes is not known now, and therefore we have not offered sufficient mitigation assistance. The owner has in fact exceeded the requirements of the ordinance by accommodating the requests of the residents at the public hearings that the appraisals were too low. If we were strictly following the ordinance, we would submit one appraisal, that which was done in April 2013. The owner's amendment stipulated that the owner will pay at a minimum what the first appraisal was, and anything beyond that. There is no cap. They talk about a floor. The floor is the existing appraisal. That's the floor. Many mobile home conversions ordinances throughout, many mobile home park conversion ordinances throughout the state of California, including neighboring cities of Sunnyvale and San Jose, ask for the appraisal to be done at the outset within 6 months of the park owner's appraisal. So for example, in Sunnyvale, you don't do the appraisals at the outset like we did them here. You do them after the approval of the conversion impact report. The Residents Association is suggesting you can't possibly approve this without knowing the amount of those appraisals. Well, apparently neither can the city of Sunnyvale and San Jose, and they have had those ordinances in place since the 80s. Then with respect to the expert last night, Louise Seppel, who was certainly clear and concise in her comments, I submit to you that her testimony goes, that her experience goes to the weight that you should give her opinion. Because Ms. Seppel is not a housing relocation specialist and did not demonstrate or speak to any experience in the actual relocation of mobile home tenants in difficult parks such as this one or in any type of park. On the other hand, Dave Richmond, the housing relocation specialist who is appointed here, for example, he was hired by the city, and this is in our closing brief. We show a sample of the agreement. He was hired by the city of Capitola to close a park because it lay in the floodplain. That was done in 2011, 2012 by the city of Capitola. And he, in fact, he has done many mobile home park closures as a housing relocation specialist. He's not begun his work here because this matter of the mitigation assistance has not yet been decided. And I would submit that the proposed lump sum mitigation assistance does provide sufficient options for the residents to relocate. You have seen now examples of homes at Buena Vista which are not in fact mobile homes. We have told you there are 30 of those. That is not in dispute. There are 98 homes at issue. That means that there are 68 homes which are RVs or trailers. RVs or trailers can be purchased for less than what they are suggesting is the a comparable mobile home in the Trulia listings at a park in Mountain View. Further, if a tenant buys a mobile home in a traditional park, the housing relocation specialist stated that the residents could obtain loans on those, they could obtain financing if they qualified. There were residents who spoke last night that said, in fact, that they do have loans on their homes. Finally then, since the orange light is on, I want to suggest to the city, and I know you will probably think that I'm somewhat speaking out of turn, but in my true belief, what can the city council, no doubt, was moved by the testimony last night. What can they do to assist the residents of Buena Vista? First, you can offer Buena Vista residents a right of first refusal to affordable housing in the city of Palo Alto that you are going to build. I realize that is not up for discussion tonight, as the Vice Mayor noted, but that is an option. The second, you can accept the legal position of the Residents Association. Can I have 2 seconds to just finish that?
Just finish up.
Just that thought. They have been arguing since the first time they wrote a letter to the city attorney in this matter that the California Relocation Assistance Act applies to the city, and therefore that would require the city to purchase comparable housing for the Buena Vista residents. It does not let the park owner off the hook in any way. The park owner pays the mitigation assistance, which is in Exhibit A. But the California Relocation Assistance Act would require the city, if you decided to do so, under that act, to purchase comparable housing for the Buena Vista residents. Thank you, and I appreciate your time.
Thank you both very much.